Welcome to this explainer. I am absolutely thrilled to have you here. Today, we're undertaking a highly focused, comprehensive lesson on a truly vital area of maritime security law. If you're serious about understanding exactly how international law governs our oceans, you are in the exact right place. We're going to unpack the legal framework of maritime terrorism systematically, and we'll keep a patient, structured pace so you can truly master these concepts. All right, let's dive right in. Here is our roadmap for today's lesson. We'll start with the gap in piracy law, move into the Achille Lello hijacking, break down the SUA convention offenses, explore jurisdiction and the concept of extradite or prosecute, look at post 9/11 expansions, and finally wrap up with local application and a recap. So here is the absolute core of what we're talking about today. Maritime terrorism is politically motivated violence at sea, and understanding its legal framework is absolutely crucial because it closes a dangerous gap in international maritime security. Let's start with Section 1, the gap in piracy law. To really understand why a completely new legal framework was even necessary in the first place, we have to look at the glaring problem that existed before 1988. Back then, international law had a massive blind spot, and it stemmed from the United Nations Convention on the Law of the Sea, commonly known as UNCLOS. You see, under UNCLOS, for an act to be legally defined as piracy, it must meet something called the private ends requirement. In plain English, that means the violence has to be committed for personal or financial gain. So think about it. If a criminal hijacks a ship to steal its valuable cargo for a quick payout, that is piracy. But if a group hijacks that exact same ship to make a political statement or demand policy changes, it isn't legally considered piracy at all. The precise legal rule remains: without private ends, it is not piracy. This strict requirement created a genuine and very dangerous legal vacuum for terrorism at sea.
That brings us to Section 2, the Achille Lauro hijacking.
International law rarely evolves in a vacuum, right? It usually requires a catalyst, often a tragedy, to force the international community to adapt. We need to walk through the factual anatomy of this specific 1985 case study, because this isn't just background noise, it is the essential context that forced the creation of modern maritime terrorism law. In 1985, members of the Palestine Liberation Front seized an Italian cruise liner, the Achille Lauro, while it was in the Mediterranean. Their political demand was the release of Palestinian prisoners held by Israel. Tragically, during this hijacking, they murdered a wheelchair-bound American passenger named Leon Klinghoffer and threw his body overboard. And the aftermath? Well, that's where the international legal system completely broke down. Egypt essentially allowed the hijackers to leave the country by plane. The United States military then intercepted that exact plane to stop them from escaping. This sequence of events brilliantly and terribly illustrates the total chaos that ensued. You have an act of extreme violence, but remember our rule from earlier. Because it was politically motivated, it wasn't legally piracy. So you have an Italian ship, an American victim, and Egyptian territory all involved, but absolutely no clear treaty framework to resolve the dispute. A massive jurisdictional and extradition nightmare followed. The world was left asking, who actually has the legal right and the responsibility to put these hijackers on trial? The resolution to this crisis resulted in immediate, sweeping action. The legal vacuum was exposed so starkly that the International Maritime Organization, the IMO, stepped in directly. They drafted the SUA Convention, which stands for the Convention for the Suppression of Unlawful Acts Against the Safety of Maritime Navigation. It was adopted in 1988 and entered into force in 1992. This was a massive game-changer, creating the world's first dedicated framework specifically designed to address maritime terrorism. Moving on to Section 3, the SUA Convention offenses. Now that we know exactly why this treaty exists, we need to look closely at its specific legal rules. Article 3 of the Convention details the precise physical conduct that is outlawed, and it is incredibly comprehensive. It outlaws seizing or exercising control over a ship by force, threat, or intimidation. It covers violence against a person on board that is likely to endanger safe navigation. It includes destroying a ship or damaging it in a way that endangers navigation, as well as placing a device or substance on a ship that is likely to destroy or damage it. It even goes so far as to cover destroying or interfering with maritime navigational facilities, communicating false information that endangers safe navigation, and, crucially, injuring or killing anyone in connection with any of these acts. But here is the absolute most important takeaway from that list. Look at what is completely absent. There is no motive requirement. None. This is the entire structural point of the SUA Convention. Unlike that strict UNCLOS definition of piracy that demands a private ends motive, the SUA Convention covers the listed physical conduct regardless of why it was done. So whether an offender blows up a ship to extort money or blows it up to protest a government policy, they violate the treaty just the same. Motive is legally irrelevant here. If you commit the act, you violate the treaty.
Let's look at Section 4, jurisdiction, extradite, or prosecute.
So we know what conduct is outlawed, but how does the treaty actually enforce these rules? Well, the core legal mechanism relies on a plain language concept that essentially means no legal safe haven. A state party that captures a suspect has a strict binary choice. If state A captures a suspect, they literally cannot just let them go or look the other way. They must either prosecute the offender in their own domestic courts or put them on a plane to a country that will. The precise legal doctrine for this is ad dedere ad judicare. That's the Latin principle meaning extradite or prosecute. Jurisdiction can attach in a bunch of ways to make this work, through the flag state, the territorial state, the state of the offender's or victim's nationality, or even just the state where the offender happens to be found. When we compare these two frameworks directly, we see a really important nuance. While SUA's jurisdiction is broad to prevent those safe havens we just talked about, it is actually meaningfully weaker than piracy law in terms of enforcement. Under UN Clause Article 105 for piracy, there's true universal jurisdiction, which grants automatic seizure rights on the high seas. Basically, anyone can stop a pirate anywhere. Under the SUA Convention, however, enforcement generally requires the offender to already be present within a state party's reach. It doesn't grant those automatic high seas seizure rights in the same universal way.
Next up, Section 5, Post-9/11 Expansions. Over time, global threats evolve, and the law has to respond to new realities. Following the devastating attacks of September 11th, the international community realized something terrifying. Just as terrorists used commercial aircraft as weapons, a massive commercial ship could be used in exactly the same way. So the 2005 Protocol additions significantly broadened SUA's scope to explicitly cover this exact scenario, using a ship itself as a weapon to cause death or serious damage. The updated rules also explicitly outlawed transporting weapons of mass destruction-related materials, transporting known terrorists, and using biological, chemical, or nuclear weapons, commonly referred to as BCN weapons, directly from a ship. That 2005 protocol also solved a major legal roadblock: exclusive flag state jurisdiction. In the past, if a ship flew a specific country's flag on the high seas, literally only that country could legally board it. The 2005 expansion introduced new shipboarding provisions. This specific mechanism allows a state party to request the flag state's permission to board a suspect vessel on the high seas, provided they have a reasonable suspicion that an SUA offense is taking place. This directly addressed the traditional bottleneck that used to block critical enforcement actions. And as a quick aside, it's vital to note that the SUA Convention strictly covers ships. But you might be wondering, what about stationary offshore assets? To protect those, a companion instrument was created: the 1988 Fixed Platforms Protocol, which was also updated in 2005 alongside SUA. This parallel protocol closes the identical legal gap, but specifically for oil rigs and offshore installations located on the continental shelf. Finally, Section 6, Local Application and Recap.
To ground all these international concepts in a real-world, local context before we review, let's look at the tragic 26/11 Mumbai attacks. During those attacks, a fishing trawler was hijacked and used as the delivery mechanism for a politically and ideologically motivated attack. Now, this is exactly the kind of scenario the international SUA framework was built to address. However, it's really interesting to note the practical application here. India is indeed a party to the SUA Convention, but they layer it alongside their own domestic laws. In the case of 26/11, the prosecution was actually carried out under India's domestic counter-terrorism law, the Unlawful Activities Prevention Act of 1967, or UAPA, rather than relying solely on SUA's international mechanisms. Okay, let's cement your mastery of these concepts with a structured recap. First, we identified the piracy gap, how the UNCLOS private ends requirement left politically motivated violence completely unregulated. Second, we examined the Achille Lauro case, that 1985 hijacking that acted as the absolute catalyst for change. Third, we explored the SUA offenses, learning the crucial legal shift that no motive is required to violate the treaty. Fourth, we learned the enforcement mechanism of aut tudere aut judicare, meaning states must either extradite or prosecute, leaving absolutely no safe haven. And finally, we covered the 2005 Protocol, which expanded the law to cover ships used as weapons and introduced critical high seas boarding provisions. I want to leave you with a serious thought to reflect upon as we wrap up this explainer. We've seen today that international maritime law almost exclusively expands in reaction to immense tragedies, whether it's the Achille Lauro or the events of 9/11. If the law is fundamentally reactive, what unseen vulnerability out there right now will be the one to force the drafting of the next great treaty? Thank you so much for your focus today, and keep learning.